influence policy. And on the issue of AJS in criminal matters, my thinking would be that we need to perhaps relook into how we have theorized justice to be, because the justice that you think would be appropriate as per the, the legal statutes that are present might not be the justice that someone, machinani, is looking for, okay? Perhaps 50 camels will be okay for that person, not locking up that person. And we're looking at the African context and not necessarily something that would be, a blunt application for everyone. So maybe we just need to rethink how we've theorized the concept of justice. Thank you.
Thank you very much. Mr. Rotich, ahead of you before we go to Mwalimu, so that we just finish with Mwalimu going behind. Mr. Rotich.
Thank you very much. I really appreciate the presentation of Honorable Nyatuka on court-annexed mediation. She presented some challenges there, one of which was the training of mediators. But I have an issue on the appointment of mediators. I have come across mediators who are retired teachers, nurses, policemen, and even chiefs, who, when you as a lawyer or as an advocate accompany your client before the mediator, she or she trembles because she does not know the law. And this is about court-annexed mediation. The case is a matter before the court. So I don't know whether any one of us know the reason behind the appointment of non-advocates or non-lawyers as mediators. Two, I don't know whether judiciary is really serious on this court-annexed mediation. Thank you.
We go to Mwalimu behind.
Professor, I would extend by a few seconds. I also want to react to what the first presenter talked about court-annexed mediation. Basically, I have a comment and then a question. On my part, I have also been involved in mediation. The international standards require that if you have to qualify as a mediator, you need to be trained in not less than 50 hours.
Dr. Mondi, please take us home.
Thank you very much. Thank you very much. I wish also to thank my classmate and friend, Ruth, for giving us this opportunity to talk to our colleagues on this important theme of access to justice. Now, the issues that I want to address are: one, what is the place of criminal law in mediation? Number two is public interest versus the individual concern. Number three is what concept of justice. And in this, there will be the issue of evidence-based decision-making and restorative approach to justice as opposed to punitive approach. Now, when we elect any legitimate government, and I'm being very emphatic on legitimate government, two things happen. We all collectively give them the power to govern us and make rules on our behalf, so that they make decisions that we all have to comply with, as opposed to each of us governing themselves, which would be very difficult. But number two is that we agree to pay taxes to aid them to render the services to us. Our new constitution tells us that even as we give up our powers to govern ourselves to them, those in authority, the power still vests with us. so that if there is anything that we need to review, then we can ask them to sit down and look at the laws that they have passed. And consult us. We have to participation, so that we both read from the same script. If there is a law that does not serve us and we bring it to the attention of the government, that should be evidence-based. The government therefore should be able to ensure that there is a process of conducting a research and collecting evidence that can aid in decision-making. Now, why am I saying that? Are there probably areas in criminal law that we need to relook and see how best to resolve such kind of issues? I will leave that for a moment. But going back to what one of my students said, and I thank her for recognizing that I taught her criminal law therefore becomes an area that the government is interested, because they have to protect your life and property. Why? Because you need to pay taxes to them for the government to run. But secondly, because you are the voters. Without them, we will not go to the next elections. And therefore, they're interested in your life individually and collectively. So where there is an incident that affects a certain number of people, it ceases to be a civil matter. It ceases to be an individual matter. It becomes a matter that is of public concern, because it's affecting more people, and therefore there is need to come up with a directive or a direction to ensure that a larger group of people are protected. Now, there is a group of crimes or rights violations which border on individual concerns, but also public interest. And therefore, these are the areas which need to be relooked. When you talk of criminal matters being the concern of the government, and therefore the government has to prosecute them, it does not take away what we term as satisfaction of the people who are most affected by that crime. In this case, you can call them the survivors of crime or the victims of crime. Where, for example, such group of people feel that the existing law does not serve their interest, then it means that the issue has to be relooked into. And when you take, for example, crimes like murder, sexual abuse, genocide, these are crimes that may be affecting certain groups of people more than they affect the wider society. But then there are concerns about how is the crime addressed? What is the process that is used? Is the victim or the survivor satisfied with the process, and more importantly, the conclusion of the case? Is there a closure? So that one does not feel that, yes, the case is over, but I still feel that my concerns were not addressed. And this is where informal justice systems come in. Mediation, as one has rightly put it, is a situation in which the parties appoint somebody to listen to both of them individually and together and resolve the dispute. Then the conclusion arrived at is recorded in court. This would apply especially in family-related crimes, where you have members of a community, of a society, who have special relations over and above the crime, and they would want to preserve that relation. Those are the cases that would require restorative justice, as opposed to punitive justice. Now, we all know that our criminal justice system is a punitive adversarial legal system, where at the end of it, the parties have very little to contribute in terms of what they want. Their decision is already predetermined. But does it help the parties? Does it preserve? Does it restore the relationship that existed before the crime was committed? And this is a concern in terms of the different units forming the larger nation. Therefore, this brings me to the issue of public versus individual concerns. At what point do we say that this matter is a public matter, and so we lock out the individual concerns of those who are more affected? I think this is the area that we need to discuss and debate more, see what kind of crimes are not, so to speak, adequately addressed by the criminal justice system as it is, so that we can be able to relook at this. And that therefore means that it is time for us to start thinking about research being a major component of decision making, but more importantly, a paradigm shift from punitive to restorative justice. To conclude, I think that there are those cases which we today call criminal law cases, which would be better handled under the mediation, and especially court annexed mediation, because then it means that the court has a supervisory role. And that means that we must have regulations. Whoever is to sit in these forums must be properly trained, accredited, and remain accountable. There must be an organization that can hold them accountable. There must be somebody to ensure that they do things the correct way. Sorry for speaking so much. I want to stop there. Thank you very much.
So good afternoon, ladies and gentlemen. Mine is going to be very brief. In fact, I'm not going to take 10 or 15 minutes. I'll take less, right? But if I go beyond 15 minutes, you give me a minus. Now, ladies and gentlemen, I stand before you to talk about something very brief, that is on the hidden challenges when we use information technology for purposes of accessing justice. As I stand in front of you, I have this hard copy paper. Why do I have it? There is a reason why I have it. I have what is called a laptop. I did my document. I tried to save on the desktop, although I was not seeing a desktop. Now, once I saved, I have tried to open, it says shortcut. I don't understand what a shortcut is, right? So I decided that I should carry a hard copy. Now, this laptop of mine, when I started opening it, right, it took a lot of time, and it kept on telling me that, wait, reloading. I don't understand what that is. So if I was running after an emergency and trying to open a document, probably it would not have been very possible to do what? To deliver it. Now, this document is saved on another gadget here. Oh, sorry. It is saved on another gadget here. I was told it is called a flash disk. How that information is converted from words or letters to be in this metallic item, I don't understand. And I know we had an IT specialist here, probably she will be in a position to explain. But that is how I have undergone. Now, I was told that when I make my presentation, it has to be in PowerPoint. So when I gave it to the technician here, he told me this is Word. So even if it was in PowerPoint, we still have words. Now, if I can kindly ask, are you seeing those words there? Well, at the end of it, what is important is communication. So that is the struggle I have been undergoing as I prepare for this paper that is appearing here. Basically, what I did, this is desk work. I did not go to the field, so I was only reviewing what others have written or what others have said. We all understand that access to justice is a fundamental right, and it is the obligation of states to ensure that its citizens, right, are able to access that justice. Now, we should also admit that the world is undergoing fundamental changes through the use of modern technology. And that is what we are doing now. As I speak, there is a gadget in front of me which increases the volume so that everyone can hear me. If you look at the screens here, those who are not with us are able to hear and see what we are projecting. Now, as we seek justice, I know we were faced with the COVID-19 season. This made it a bit challenging for us lawyers and our clients to access courts. But with the use of modern technology, it has been made very easy. I sit in my office, right? The other parties also sit in their offices. The honorable judge or magistrate is in court, right? We are able to talk to each other. We can see each other. We can exchange information. We can exchange documents. We didn't know that time will change, that when you have to pay court fees, now you can use a mobile phone where you have a platform of M-Pesa, and it works very well. This makes the use of modern information technology makes our work to be a little bit easier and convenient. So the focus of my paper is actually to explain what access to justice is, and this has been a household term since we began on Tuesday. I don't have to dwell so much on it to explain what it is. The use of information and communication technology, what is it? They use, I will simply, but I stand to be corrected by experts, by saying that it is the transmission of data, information, all those kind of things through the use of electronic gadgets like computers, mobile phones, and the like. Now, who are the most affected people in terms of accessing justice? We know they are the poor, the vulnerable, and the marginalized. Why? One, their literacy level on the use of these gadgets is a little bit low. Two, they are disadvantaged because of their location. We have said, and so many speakers have emphasized, that they travel a long distance to do what? To access the courts. Three, they would be having certain different kinds of disabilities to the extent that financially they are not able to fend for themselves, but they require to access justice. So the problems or the challenges that we face, that the marginalized and the vulnerable will face in accessing justice, is that the institutions that offer justice could be a challenge to access because of the distance. The dispute resolution mechanisms could be very slow. The procedure, as we have already indicated by other speakers, they are unnecessarily complex. And I know I don't want to shy off. Some of us lawyers, when we hear of judicial review, we don't want to participate. So when a client comes to my office about judicial review, you ask for a very high fees to scare off the clients. The reason being, you don't know how it is done. You don't want it. It involves a lot of paperwork, and you have no time to concentrate on that. So I'm not against those of us who do running it down because that's quick money, right? I'm not against some of us who do criminal cases because you don't file any paper, right? All that you need to know is what is the nature of the crime your client is facing, right? And you prepare, you go to court, and you wait for the prosecution to do what? To prove. But now, when the judiciary introduced the use of information and the communication technology, I stand to be corrected, but I thought this was geared to parties who were represented. Lawyers could easily do what? File documents, upload them, right? Send them to the other parties, forward them to courts, and it becomes very easy. But how about litigants who are not represented? How about litigants who are not educated on matters of information technology? They have always had challenges. some of the things, some of the gadgets that are used to make, to enable us access justice very easily. We can use radios, we can use televisions, we can use mobile phones, computers, internet, or commonly known as Wi-Fi. Now, I get a problem when my gadget, I'm trying to scroll it down, it is refusing to move. So I want to believe that those are the challenges you would expect. Now, we have court decisions which explain what access to justice is, and as I've already said, that one has been explained by many scholars here, but I will simply summarize. It entails accessibility, appropriateness, equity, efficiency, effectiveness in terms of service. I labeled my presentation, and the key word that I want to emphasize on is the hidden challenges when we use this information technology. How are they hidden? You proceed and we praise the use of modern technology, ICT, but we forget that there are side effects that come along with it, which affect access to justice to most of those who are seeking justice. Number one, and this is the center of focus, violation of a right to a public hearing. The Constitution of Kenya, international instruments emphasize on the essence of a public hearing. So when we are doing hearings online, how many of us can access that public hearing? I know for me to get to court for a hearing online, I have to be given a link. And even that link, I'm told, yes, I have it, but I have to be admitted, right, to participate in the proceedings. So a link is just like a key that enables you to open the door. You can open the door, but if you are not told come in, you will see not enter, even if you have the key. So many of us, many litigants have that challenge. They do not understand what the link is. They do not have the gadgets. And if they wish that the case be heard in public, where anybody, like in this forum where we are, somebody will just walk in and follow proceedings, it's not going to be possible to have that public hearing. To me, I got this to be a violation to the right to a public hearing to those of us who are interested in doing what? Following the proceedings publicly. You can see Article 50, sub-article 1 of the Constitution, emphasis on public hearing, and also Article 50, sub-article 2, in as much as it talks about criminal cases, but this obviously applies to civil cases, not unless parties request for a private hearing. And I know I was recently doing a divorce case. It was a little bit a challenge. People have the link, yes, but you know there are certain matters that you do not want to expose to the general public. So we need a bit of privacy. So we had to do a hearing before the normal hearing court session starts. And this brings me to what we call security breaches. Yes, you have the link. Online hearing. You are going on, right? We are talking about private affairs. Business, parties who have business disputes, they don't want their competitors to know what is going on, right? During the hearing. Just like it happens in mediation and in arbitration. But now, I'm not very good in these matters because I'm also learning. I have heard of the term hacking, right? That people can access even your email, they can access your data, which you have saved in these gadgets, and they can use it to your disadvantage. This could be probably a criminal case, but we have cases where people access computers, right? Access information without permission of the user or the owner. Now, take the example. I don't know whether this works well. The 2-judge bench or 3-judge bench, they're writing a judgment. One judge emails his judgment to the other. It does not become official. But I have Muiruri here, who is an expert in these IT things. He is able to access that judgment before it is brought to the general public. That will be a challenge that we are having because it interferes with the privacy of parties to the proceedings. Parties who have stored their information
in some of these gadgets. Now, the other challenges that you have, these are not hidden. You are able to see them practically. Lack of internet connectivity, right, makes it difficult for us to do what? To be online for purposes of accessing the court proceedings or sending documents. We know this internet, fine, it is available in some cases, but at times, as I was seated there, and I've been sitting from Monday, Tuesday, I am using data in my phone. Occasionally, it disappears. And just imagine if I was online doing a hearing. How many times will I tell the court that I've gone off? And at what stage do I say that? We have the issue of resistance to culture change. I don't know, I could be one of them. I am not prepared to go to a class to study computer at my age now. I don't want to be in class with my son, right? Or even my grandchildren, who are able to do these things without going to class, right? I don't know what is a hardware and what is a software. It becomes a challenge to us. Even in the judiciary, I know that those who want to use the traditional way of writing proceedings, right? They want to do open court, and they look at a person who is not able to travel a long distance to attend court, right? These gadgets can help. We also have a high level of illiteracy in information technology issues. Honestly, if you have not been trained on how to use these gadgets, it becomes a challenge. We have poor infrastructure, especially in Kenya. Some places cannot be reached. Yeah, we have a poor road network, poor supply of electricity, and even when it is purported to be there, it keeps on going off every now and again. When it comes to e-filing of documents, fine. Personally, I have a challenge. I send a document, I'm told it is hanging in the ICs for 1 week. It has never reached. Then you are told to send again. Is this just delayed? Or is it just that we're going to get very fast? Legislation. The way I get information technology is a progressive area, right? We pass legislation today, tomorrow we have new concepts under ICT. So legislation is not able, the pace at which ICT changes is not proportionate to the changes of legislation. You'll find the legislation was passed yesterday by our parliament, but today we have a new platform that has been created by IT people. To regulate it, to manage it, it becomes a big problem. So what do I suggest? A legal framework that is adequate and addresses issues, security issues and privacy issues for those of us who have stored information or who have information online. We have the problem of funding. It's a suggestion that if the judiciary, the courts are properly funded, they can be able to have sufficient gadgets, they can be able to have sufficient internet to be able to withstand, right? The number of litigants who are online. You heard that one of the officers said that they are using the same link. We have 10 courts, one court has to finish, and another one starts. Delayed justice. The government and the private sector, what do? We should educate members of the public about the use of this ICT. We should embrace it. Where it's not easy, alternative systems of justice can enable people to access justice. I am not saying that when alternative systems are used, that we do not use ICT. No. In the rural setup, where we have these problems of infrastructure, alternative systems of justice, traditional ones, mediation, they can work. And finally, I want to emphasize this, that as the world keeps on changing, and these changes are being brought by technology, there is no way we can ignore it, despite these hidden problems. It is important for us, right, to be able to use it, embrace it, for it is part of the administration of justice. Thank you.
Good afternoon. First of all, I'd like to extend my gratitude to the United Nations Development Program and the follow-up for this opportunity so that we can be able to promote access to justice even in the midst of this pandemic. Now, my name is John Jakinda, and the topic of my paper is Perspectives on Access to Justice in the Midst of the COVID-19 Pandemic, Addressing the Challenges and the Responses Thereafter. Now, before I go to the gist of my paper, I saw it prudent to reflect on the justice, how the National Legal Aid Service has been able to develop, because it is the first institution that made it possible for the indigent to be represented without the need of paying fees that is usually crucial in the justice sector. Now, in 1999, there was the National Legal Aid Steering Committee that was spearheaded by the Office of the Attorney General. It focused mostly because previously access to justice was mainly anchored on the fact that only the accused persons who lacked representation in capital offenses, the only ones eligible for legal aid. But due to public demand, we could see the various stakeholders emerged and ensured that even those not in the criminal sector can be able to access justice even without paying anything in regards to legal fees. Now, from the Ministry of Constitutional Affairs and the Ministry of Constitutional Affairs and Justice, which was the minister by that time was the Honorable Matakarua, who was described as the Iron Lady during those days. She's participated in this model of providing, of being able to address access to justice to the indigent. And in that, you could see the Legal Aid Act was able to be passed, and access to justice was now expanded even to people who could not be able to access, apart from criminal proceedings, those cases which were capital. You could see access to justice was able to cut across even in children matters, in land matters, public interest matters, which was seen in the Ogiek case and many others. Now, turning my attention to my study, my study is divided into 3 parts. I started with the challenges, the overall observations of the challenges on access to justice during the COVID-19 pandemic. Then I've been able to address the responses and the proposed reforms that will be aimed towards improving access to justice. Now, in my studies, the current situation, I was able to reflect on the comment made by Woodrow Wilson, who was the President of America, the 28th President of America. He stated that in every crisis, you should be able to invent new things. Don't let it go to waste. And you can see that that is the current situation we are facing now. Previously, when I was attending one of the seminars presided over by the retired Honorable Beverly McLaughlin, the former Chief Justice of Canada, she stated that the justice system was mainly anchored on physical hearings. In a case where a person must attend court, and in that scenario, the judge will be able to listen, and there was no room for virtual hearings during that time. Now you could see courts across the world, they are mainly anchored on the physical system of providing access to justice. But the emerging of the COVID-19 pandemic, it enabled most stakeholders to be able to come at a conclusion that even when a crisis strikes, like the pandemic, which nobody was able to foresee, it could be possible for justice to be able to be delivered. Now, in that regard, some of the challenges that I was able to pick up was in regards to the emergency legislations. If you look at our current situation, like in Kenya, there was this bill in Parliament known as it was spearheaded by the Senate ad hoc committee it was known as the Pandemic Response Bill, which was aimed at it was the ad hoc committee they brought that bill to into the Senate in order to respond to the emergence of the COVID-19. And you can see in this bill, it had proposed funds for the indigent persons. It was, I think it's still in the Senate, it has not been ascertained to, but you could see they could be able to to be able to respond to the pandemic. And I used the comparative analysis of South Korea. In the case of South Korea, there was the reform bill for the civil procedural rules for video conferencing. Now, this specific bill, in which was passed by South Korea, it was aimed at enhancing pre-trial hearings in regards to be able to respond to the emerging COVID-19 crisis. Now, in this bill, it provided that before parties embark on a legal suit, they should first consent. Both parties should conduct a pre-trial conference, like the ones which we see in the Republic of Kenya. They should first consent and agree which way forward they can proceed, either physically or through virtual platform. And you could see this when the advocates of this bill were able to discern certain strategic points that could be able to guide potential litigants. You could see, since the emergence of the COVID-19 pandemic, there was rise in cases of domestic violence. Children were being abused because you could see the parents were being frustrated because maybe they have lost income. Now that frustration, they pass it to their wives maybe and their children, and you could see such cases now began to pile up. And while I was looking at those statistics, I was able to encounter one comported by the National Legal Aid Service, which is the main organization that tackles matters legal aid in Kenya. And there was a statistic that since the emergence of the COVID-19 pandemic, the cases reduced from 469,359 to 289,728. You could see the cases reduced by half. This means that when the COVID-19 emerged, the courts were closed. Now the indigent, they lacked that platform that they could be able to access justice. You know, most of the aided persons, they are used to this justice system where you go to court, you report your matter. They were not used to filing cases online. Now you could see how the number reduced close to half. You could see the problem which brought how the COVID-19 impacted access to justice, not only in the judiciary, but also in regards to those people seeking legal aid in the National Legal Aid Service. Now, in this case, I was able to assess and see how I can solve such problems. You see, in most of these problems occur in the rural setups. And in those rural setups, it is only the paralegals who can be able to help these people, because they are the ones who are, like my senior has said, the one who was before Mr. Getanda, he had stated that the paralegals are the ones who are majorly based in these community-based organizations. They are the ones who sit with these people from the rural setup, these marginalized areas. They can spearhead and ensure access to justice is enhanced by bringing into attention these cases and maybe confront various people who could be helped, like the National Legal Aid Service. They can access the courts, and they can use other avenues that may be suitable so that access to justice is not hampered. Another area I saw that which I was able to discern, I looked at, there was a case in England. The case is the Republic versus the Lord Chancellor, ex parte Lord Witham. Now you can see in this case, the Lord Chancellor was empowered to increase court fees under the Supreme Court Act of 1981. That one is in England. Now, the new regulations removed provisions that had exempted the remittance of fees for indigent litigants. And upon reviewing of the new regulations, the English courts determined that the regulations were indeed ultra vires as they denied the applicant his constitutional right to access to justice. Now, looking at this case, I could be able to discern that in this case, the Lord Chancellor, he had used his powers in the sense, he had misused his powers in the sense that he had seen like access to justice to the indigent it was not proper because he saw it like these people are not paying any fee. Why should they be allowed to access justice? That's just because the judiciary must run, the court must run. Now, why should they be just allowed to just bring their cases, they be heard, and they at the end of the day they get justice without paying? But you can see even the court was able to say, even if you are the Lord Chancellor of England, still you are wrong because not everyone is well off in the society. There will always be those ones who cannot be able to access justice. And you can see he arrived at the court arrived at a valid conclusion when he stated that indeed his actions were ultra vires. Now, another challenge I was able to encounter is the challenge of the practice of unqualified advocates. And the case of Godri Obura versus Martha Koome seems to hold water in regards to that area. In this case, the court stated that in order for no person shall be qualified to act as an advocate unless he has he has been admitted as an advocate and his name is for the time being in the role of advocates. Now, in this case, in regards to this case, we could see since the emergence of the pandemic, there has been some people masquerading to be advocates because of the online court system. A person can masquerade, even a court clerk. There was a case I think in Naivasha a while back. There was a clerk who was masquerading to be an advocate. And it was a land matter. He took the case from this client until the end now the case was able to discover when it was, I think, before the judgment was pronounced. And you can see this person was able to masquerade as an advocate until to the extent that he was able to beat his opponent who was a qualified advocate. Now you could see in such instances, his opponent, I don't know how he was able to fathom because he was beaten by someone who has never even attended law school. He was just a clerk who finished his secondary education, and he worked as an advocate, I think, for about close to 20 years now. He has interacted with the law, and these are the problems that we are experiencing because an indigent has no ability to discern who is a qualified and an unqualified. A person who has gone to school can be able to go to the search engine and determine that this person is duly qualified. But an indigent, he will just come to you, and that court clerk or anyone who is appraised with the law will take the case and proceed with it. And you can see the indigent justice can be hampered because the judge or the magistrates can refuse to grant those rights which have been abused by those rights which were in questions abused. And you can see justice cannot be delivered in such instances. So the judiciary should come up with ways to ensure that the indigent are able to access justice, and they should come up they should devise ways, maybe through information technology, so that they can be able to ensure that those people who are masquerading can be able to be discovered. In conclusion, I like to state that I like to echo the words of Woodrow Wilson that indeed, even if any crisis hits even if it's in the entire continent like the COVID-19, you as the justice defenders should not let it be an excuse not to provide legal aid to the indigent, especially at a time like now when they need it the most. Thank you.
Thank you, Mr. Uganda, the moderator of the session. It's my great pleasure and honor to stand before you. I start by appreciating the invite that came through the Dean, Egerton University, Dr. Ruth Aura, and also commend UNDP for organizing such a program. So before you is Dixon Gitonga, a researcher with the National Crime Research Center. I'm sure there is a few of us who joined us today, either basically or those who are online, and they did not get an opportunity to know who is this presenter. So as Mr. Mwirori do the setup for my PowerPoint presentation, allow me to mention a few things from where I come from. I work for an agency in the Ministry of Interior by the name National Crime Research Center. National Crime Research Center is mandated to carry out crime-related research in the country for the purpose of policy advisory within the criminal justice system. We also collect data from the agencies, that is from the police, ODPP, from the prison, on matters of interest, of concern in the country. And most of our studies are informed by three things. One is on what is trending in the country. Recently, you are aware, even at the moment, we are in the issues of school banning, of secondary school, mainly boys boarding secondary school. We did a study in 2016, and we were asked to do an advisory by the National Security Advisory Committee. At the moment, we are also in the stage of doing some data analysis of a study that we conducted on election-related crimes and offenses in the country. You are aware that we are moving closer to the electioneering period. And one of our mandates is also to evaluate programs in all the agencies in our country. So my study is on my presentation will be based on a study that we did. Let me start by putting a disclaimer. It is not my study. It is a study that we did as a center. So I'm here to represent also my colleagues who also could be also following what I'm speaking about through other forum. It's a study that we did in sometimes back last year, 2020, between June 2020 to July 2020. We were asked by the HE, the president, to probe three issues in the country. The first issue was on escalating cases of gender-based violence in the country. The worrying trend of cases of where girl child has been disempowered and violation of children's rights. I'm sure during the lockdown period, most of us were very concerned with the state of the nation address on COVID issues. So if you Google the ninth state of address to the nation by the president, you'll find the assignment that were given by the president. So I'll start by a quote. In that the State of Nation address, the president is saying that we must always remember that the family is a projection of the state, and if the family is under attack, the state is under attack. If the family is weak, the country is weak. That is what the president said in his remark. So let's go straight to my study. I've already mentioned about what we do. And I've already mentioned that this study was informed by what was happening during the COVID period. I don't need to go back and try to give the numbers of what was happening during that time. And in our Constitution, Article 45, says that recognizes the family as the natural and the fundamental unit of Kenyan society. And that's the reason why even the president of the nation was very much concerned about it. And also during that time, when the COVID came to our country, the numbers were rising. There were cases of increased cases of SDBV, children right violation. And if you look at my slide number 9, we have already given the numbers there. By 2019, there was also a study that was conducted, and the figures are indicated on the board, whereby 62.6% of females aged between 13 and 24 years and experienced multiple incidents of sexual violence in childhood. This was now the period before the COVID came to our country. We moved to slide number 11, Mr. Muilori. So the problem of this study and what made us to conduct this study was to really understand, to try and understand why is it now people who are in one family that there was that increased incidence of people fighting in the family, cases of violation of children within the family. And we wanted to really understand what is the problem, because these are people who live together in the family, and now there is no peace in that in that home. During the same time, there was a lot of media report. Every time in the news, we could hear, let's say, a place like Nakuru or even in Naivasha, there is a man who has either hacked the wife to death or even butchered his family. And we really wanted to understand what could be the problem. Is it because of COVID? Is it because now people are not working or they are staying at home? And NCAJ asked us now through the HE president to do that, to conduct that study. The methodology, because the time was very limited, we had about 4 weeks, so we could not go out and correct primary data. But because we are within, we work in collaboration with other agencies, so we were able to request for data. One of our mandates, if you look at our act, that is the CAP 62 laws of Kenya, we are mandated to collect all the data. So we requested for data from National Police Service, from the probation, the Kenya Prison, the government chemist, Ministry of Gender, Gender Department, DCS, and also we engaged other non-state actors, civil societies, who are concerned with the matters of children rights. So allow me to move to the finding, and I would have started by saying this. I'm sure, Mr. Oganda, what I'm presenting here, my study is very related to what Dr. Pasitau and what Dr. Ruda presented. So I'm very sure you're going to earn me some more minutes, because I don't expect a lot of questions in this subject, because already we have 2 presenters also speaking about the same. So the finding, this is, as I've said, this is an evidence-based research. We were able to find out that from the State Department of Gender, that within that period, 71.0, that is 2,416 cases of DBV, and been reported at between January and June 2020, and we have the victim mostly were female. From the National Police Service, between January and June 2020, a very close figure to what the State Department of Gender and recorded, 2,000 cases, 2,032 cases were also reported. That is an average of 11 cases daily being reported to the police. You can imagine. And also between earlier on, that is now in comparison, between January and December 2019, you see in 2019, that is now before COVID, there were about 1,057 cases that had been reported. So you see there is a spike increase of cases that were reported during the time of when COVID cases were reported in our country. On issues of gender-based violence reported to the police, we did a comparison of 2018, 2019, and 2020, and you'll see from what is projected on the board, cases of assault, rape or attempted rape, murder, indecent assault. What was there in 2018, 2019, and 2020, you can see there is an increase. Assault, we had 1,615 cases reported between that is January 2020 to around June. Rape, we had 223 cases. Then we had murder, an increase that is now more than what was reported in 2019. However, in 2018, there were more cases reported in 2018. Then indecent assault, we had 63 cases. So what we recorded here is now between January and 20. So you can imagine if that was 6 months with the cases of murder being 131. So by the close of the year, there could be double. There could be double cases reported to the police. On GBV cases during the time, what was reported by the probation and aftercare service, you can see on the board that there was an increase of the total number of cases reported within the 3 months. That is between January to March 2020, and also between April to June 2020. I'm sure I have about 15 minutes now. Then figure 2 is on cases reported through channel in Kenya. As I've indicated, before we started this process of collecting data, we had a forum, stakeholders forum. We had an online invite with civil societies that are concerned on matters of gender-based violence or even issues of child protection in Kenya. So we also had an opportunity to get a representative from Children Kenya, and we were able to analyze their data. You can see down there the total number of cases reported within the 3 months. That is between January to March 2020, and between April to June 2020. So there is an increase. You see cases of sexual abuse. Between the 3 months, we had 103, close to what was reported to the police, recorded or reported now to through the anonymous reporting channel in Kenya. Violation of children rights. These are the cases that are recorded by Department of Children. I'm sure you are aware, all of you are aware that in every county and sub-counties, we have Children Department Office. They are mandated to look at the welfare issues of the children for purpose of care and protection. And we did a comparison of 2017 and 2019. You see between January and June 2020, 209 children had been, their rights had been violated. Yeah, that is daily in the country. Cases that were being recorded by Department of Children daily. And that is a very big number of cases being reported of such nature. Then you see also on issues of, that is between now April and June 2020, also from DCS, the kind of cases that were being reported to the offices. We had issues of children who have been displaced, either the mother and the children, they are no longer interested to take care of the children. Children who had been unlawfully confined, either taken away, either by one of the parents, either the mother or even the father, taking the kid away from one of the parents. And also cases of genital mutilation were also recorded during the period. On violation of children rights, they also increased during the period of April to June. You are aware that in around March, we are under cessation of movement in the country, and from what what was recorded by probation and aftercare service, there were cases of violation of children right during the period. We had cases of defilement being recorded with an increase. We had cases of attempted defilement, grievous harm, killing of unborn child, and abduction. So those are the figures. You get an opportunity to get the full report later, and also the PowerPoint presentation in the interest of time. We also got data from China and Kenya, and also if you look at the data, there is an increase of cases of child abandonment and also child labor. Cases of also girl child disempowerment was also recorded by Kenyan National Bureau of Statistics and also DCS. You can see the figure that is on my slide number 22. I'm almost through, Mr. Uganda. There is an increase of, when we did the analysis, the figures was, we were getting around 300% increase of cases of girl child disempowerment. That is either genital mutilation, defilement. So we lumped all those cases as disempowerment of the girl child. The figures are also on the board, as you can see from DCS, Department of Children. Allow me to move to the perpetrators. The perpetrators of GBV from our analysis, that is the slide number 26, Mr. Murori. Generally, they are youthful men. Some are acquaintances, neighbors, girlfriends, and boyfriends. The State Department of Gender recorded cases of GBV that they emanate from the spouses. One of the spouse may be attacking the other, one becoming a victim, and the other one being a perpetrator. The same case with the DCS. Disempowerment from the children right violation from the NPS, the police. They recorded youth and relatives are the perpetrators, and adult, the same case with others. Allow me to move to the root causes. The root causes could include death of one parent, as you can see on the board. I've put this right just to update ourselves on what was reported yesterday during the WOWN's in day, that between January this year and October, 274, 510 cases of teenage pregnancies had been recorded, and the causes was poverty and issues of gender inequality. In the conclusion, we are saying that there is likelihood of increase in family-based crimes and offenses and violation partly due to the circumstances of COVID-19. This is similar to what Dr. Aura and Dr. Pasitao and mentioned in their report. Allow me to move quickly to key policy recommendation. I'm sure you know that we have UNDP around here, and they could pick one of our policy recommendations for purpose of either programs for the concerned agencies. We are saying that there is need to inspire a national agenda and campaign to reclaim the Kenyan family in an organized manner and a structured way. We are also saying that there is need to strengthen the DCS and the National Council for Children Services, especially sensitizing Area Advisory Council, which brings together state and non-state actors. We also need to prioritize management of cases of GBV and matter issues of children, establish a one-stop center for survivors of GBV, hold regular exchange of ideas, and set up local parenting and fatherhood clusters to fight family-based crime and violence. Like the concept of Nyumba Kumi. We're also thinking that the governors and the county executive may also need to come on board and also try to support in managing this. We're also saying that we need to a strict regulation on how second generation of RICA and HACO is being distributed in the country, and also continue or empower our education system on matters of violation of children's rights and issues of GBV, and also formulate and implement plan of out of school programs for purpose of awareness creation. And the last one is we were thinking of having a dialogue, a summit, which either can be supported by the government or also other non-governmental organization on issues of empowering or knowledge sharing on how we can improve on our value system on matters of child care and protection in the country. I thank you.